Good afternoon. I won't show you my PowerPoint slides because the comprehensive presentations that have come already have basically covered all the topics I was thinking of talking about. I want to make some more general remarks about notice procedures. I come at this from a slightly different perspective from, I think, many people in this room. Not from the intellectual property perspective, but from the perspective of someone who works in the area of defending what you might call personality rights, defamation, privacy, data protection. It seems to me that the first and important point to remember is that a notice procedure is itself already a compromise between, on the one hand, strict liability, and on the other hand, complete immunity. Now, strict liability, you may think sounds like an outrage, but basically that's the way the law, the common law operated for many centuries, including in the United States until 1963. The position being that for example, the publisher of a newspaper is liable for defamatory content, whether or not they know it's there, and certainly they don't have to know it's illegal. Very often they don't know it's illegal at all. The famous cases of famous common law cases where simply a name has been used and there turns out to be someone else of the same name in a way that the publisher wouldn't know about at all, they're still liable. Now, that regime may be thought to be too strict, but that's the traditional approach to publishers and liability. The position in relation to internet and online internet information society service providers, we have slipped into assuming that the approach from the Communications Decency Act is somehow the default position, or at least some notice procedure is the right way of doing it. I sometimes, I'm not going to suggest that having some kind of notice procedure should be got rid of, and there should be some kind of strict liability. But I sometimes wonder what actually the rationale for this is, because there's an assumption which is very rarely examined that if information society service providers were to be made strictly liable, this somehow would lead to immediate ruination and economic collapse. It's not quite clear to me that's what the position would be. But I'm not going to argue against it. But I want to make this as my first point. It's got to be remembered that having a notice procedure at all is already a decision to strike the balance very much a long way down the scale. So if you think of the fundamental rights that are in play in relation to the publication or dealing with material on the internet, talking in charter terms because it's easier, Article 7 privacy, Article 8 data protection, and then on the other side Article 11 freedom of expression, information, Article 16 the freedom to conduct a business. Having a notice procedure has already struck the balance at the freedom of expression, freedom to conduct a business end of the spectrum. It's not in the middle. It's very much over at one side. Now, the freedom to conduct a business is itself a rather weak sort of right, and freedom of expression is a complex question in the context of intermediaries, because intermediaries are not generally thought to be exercising rights of freedom of expression, and the freedom to receive information is a complex and rather weak sort of right under the under conventional analysis of freedom of expression case law. I'm not going to go into that, but the position of a notice procedure is already to, as it were, fix the game in favour of one of the players. That seems to me, if we start from that perspective, that seems to me to cast useful light on some of the questions which Yanni was talking about earlier, where he was talking about the case law and the approach that's been taken. You can't. It would be double counting in the game, as it were, to say, oh, well, we'll have a notice procedure and we'll assume that freedom of expression has priority, because that's cheating. The so-called Manila principles. When I first read these, I wondered whether they'd been produced by someone doing a parody, but apparently not. They are apparently a serious analysis of what the liability of intermediaries should be. So they assume that you have a notice procedure, and then they have to assume that notice procedure is fixed entirely in favour of the intermediaries. Well, that it seems to me is the wrong way round. If you have a notice procedure, the notice procedure should be interpreted in a way which generously accommodates the privacy rights, the reputational rights, the data protection rights, and the property rights of those whose rights are being infringed. Because the reality is that the operation of these of internet of information society service providers of Google, of Facebook, and all the other ones we've been talking about involves on a daily basis massive and uncontrolled infringements of the rights of others. Paul made the point in his presentation that it was what I think he described as a paradox, that it's read more often and regulated less than the traditional media. Well, it's a paradox which, of course, has a very simple explanation. I think Google made £94 billion profit last year, so it's not surprising it could afford to employ a lot of lobbyists, and the effect of those lobbyists is that it's subject to very light regulation. But just going on to the questions about practical questions about how notice should operate, it seems to me that dealing with, Yanni mentioned some of the issues which are set out on the conference programme, and if you just think about, from the perspective I've been outlining, that the need to give an effective remedy. I mean, Article 47 of the Charter, the right to an effective remedy. You've got to have an effective remedy for the violation of your personality rights. And if you fill in an online form, send it to Facebook, and then 6 weeks later you get a standardised response saying no, that strikes me as not really in anybody's language an effective remedy. So in terms of the approach that's taken, it seems to me you've got to bear in mind the need for an effective remedy on the parts of those whose rights are being infringed. So, taking the first question, what level of knowledge is if you're having a knowledge-based standard before there's liability on the ISS? What standard of knowledge should you have? Well, the words of Article 14 seem to me to have to be construed in a fashion that's generous to the person who has the rights. Too rigorous a standard of knowledge can't be applied, because if it is, those rights are not subject to effective protection. It's interesting in the CG and Facebook case. One of the big arguments was that there had been an original Facebook page called Predators, where the person whose page it was basically exposing addresses and personal details of paedophiles and encouraging people to go around and beat them up and cause them personal harm. That page had been closed down, and then the very same person set up another page called Predators. And Facebook was seeking to argue that really they knew nothing about the second page. I mean, it's the same person, it's got the same name and the same content, but how should we know? Was their argument. And the letter that was written by the claimant solicitors unfortunately claimed that the page saying he had a serious conviction for child sex offences was defamatory, which wasn't quite the right way of conceptualising the wrong. But the fact that added to the knowledge that, at some point, someone in Facebook should have read that complaint and should have put two and two together with the previous complaint and realised what was going on. And that, if you were, rather than saying, well, actually, the letter has got to set out in words of one syllable the right cause of action, the right elements, and the positive evidence in support of it, it seems to me to impose too high a standard, so an effective remedy is not available. Similarly, the requirement that in all cases the URL must be provided seems to me to be too high a standard. Of course, in some cases URLs can be provided, but on the other hand, very often you get situations where the URLs change for all kinds of reasons, and in one case I was involved in, we sent a list of 200 URLs to Google and asked them to remove them, and they began by it took them 3 months to do something about it. When we got the day before the trial, one of their boasts was, we're dealing with this very quickly, we're doing it in 24 hours. Well, when they suddenly see the court case about to start, 24 hours was no problem, but before that it took them several months. But in that case, they were the person who was posting the offensive material just was constantly creating new sites. So there were 200, and then there was another 500, and then another 500, and another 500. Now that was. I'll come on to the issue at the end about proactive remedies, but the giving the URL is sometimes just too. It just doesn't provide an effective remedy. The question of speed of response. Well, I've just adverted to that just now. I noticed from Google published an article, I think it was last week, about their first year's operation of the first 3 years operation of the delisting procedure, and it took them a median of 82 days to deal with a request in 2014, and they now say that it's down to 3 days for such a request. Well, 3 days seems to me to be expeditious. 82 days, certainly not, whatever the course of action is. But again, a fairly strict view has got to be taken, it seems to me, because again, otherwise there's not an effective remedy. And the final point that I want to mention is which is, I take this, I follow absolutely religiously the conference programme. The question is whether the takedown should relate to specific content or deployment of content recognition technologies for blocking relevant content. Well, it's not an effect. In some cases, just blocking a specific content is not going to be enough. And of course, there's an Article 15 issue concerning general monitoring, but there's no doubt that the e-commerce directive contemplates injunctive relief to prevent infringements, not just to deal with. So, and that involves potential future infringements. The only case I've ever had to fight this point against Google, Google began by saying it was completely impossible for them to take proactive measures to block certain material coming into search results. After we produced an expert report, they suddenly changed their position and said, actually, it was very easy. In fact, it could be done at no cost and straight away. So the proactive measures that can be taken are certainly, in my experience, much wider than people are led to believe. And those proactive measures are sometimes what is necessary for an effective remedy. Now, I'm not going to talk about that. There's lots of, as everybody in this room knows, and probably most people a lot better than me, there's a lot of subtle case law from the Court of Justice, if that's not a contradiction in terms, about what constitutes general monitoring. But there's a kind of specific general monitoring which seems to be all right in terms of Article 15. And it seems to me, again, the provision of an effective remedy requires that in appropriate cases. Thank you very much. I think I've just come to the time.